Even though these were tried, well, go ahead. Get started first.
Good morning, Your Honors. My name is Charles Stevenson from South Hadley. I represent Mr. Chern's co-defendant.
Even though they were tried together, the issues are entirely different.
That was my
like two separate
lead
cases.
comment, was that the cases could not be more different.
Yeah.
Mr. Chern's case is all about identification. Mr. Auer's case is all about everything but identification. Right from the very outset, his attorney conceded that he was present and a participant. The arguments that I raise are far more straightforward and I think easier to grasp, certainly, than that which you just heard. On the other hand, it involves a fairly nuanced review of the evidence in the case. And that, in turn, begins with the supposition and the proposition, and I think one that the government could absolutely not contest, that this was a spontaneous fight. That, in fact, the first police officer who responded was responding to a call for a fight in progress. In the prosecutor's closing argument, I think he said it best, after the argument had transpired for several moments, all hell broke loose. This was a melee, and it was a completely chaotic situation. And in consequence, I think there were a number of inconsistencies internally between, everyone was calling her Ms. Tran earlier. I think of her as Ms. Fenglevan. She'd become married in the interim between the incident. I'll try and stick with Ms. Tran, since Your Honors are familiar with her. At one point she said that Mr. Auer was kicking the victim for 5 to 10 minutes. On cross-examination, she acknowledged, well, it was 1 or 2 times. Inconsistencies within the testimony of the various witnesses. Second, great discrepancies between witnesses. What, for instance, Jeremy Richardson, I believe his last name is, the fellow who was with Mr. Dowdy during the beginning and the very end.
Mr. Stevenson, excuse me for interrupting you. This is all very interesting, but isn't that precisely what we have the jury for?
It's precisely what you have the jury for in one context, and that is, as I think quite appropriately noted several points in the brief,
right.
I concede that there was sufficient evidence here to warrant a conviction as a joint venturer for extreme atrocity and cruelty. However, given the circumstances of the case, this Court's responsibility, both in general, reviewing the errors that I allege, and more specifically in conducting this Court's special duty to review the case under Section 33E, all of those issues about inconsistencies become tremendously important because it is the weight of the evidence and not its bare legal sufficiency, which is really at play in this case.
Mr. Stevenson, is there any evidence that any one of this group of people, and I know it was a melee, but it was a melee, at least not having read the transcript, but having read the factual summaries, I mean, escalated, you know, to a remarkable degree rather quickly. Is there any evidence that any one of the group, which would include, the co-defendants, ever said, back off, you're going too far?
There is not. And if
that's the case, I mean, what's the weight of the evidence? You've got joint venturers. I mean, it's.
I guess I would begin at perhaps the end and point out to the Court that I filed a supplemental appendix, and it is this Court's decision whether to accept that or not. But included is a photograph of the shirt that Mr. Dowdy was wearing, and it is very clearly of a deep burgundy color. Yes, as one looks at it, one can see that it is blood-stained, that there are bloodstains on it. But all of this becomes a question of whether it's knack, whether it's bowl. Mr. Churn...
Is the shirt in evidence?
Pardon me?
Is the shirt in evidence?
Oh, absolutely.
Well, then we look at the... I mean, is the photograph in evidence?
Not this particular photograph. This is a larger photograph.
No, but is a photograph of the shirt in evidence?
Yes.
Well, then we look at it. We do 33E, we look at it.
But as I understand it, whether it's knack or whether it's bowl, your guy is there participating in this melee when somebody, knack or bowl, apparently, is stabbing this victim 11 times.
Well, Your Honor, the sequence of events is fist fight that involved two discrete groups, but one which Mr. Auer was involved in, it was 3-on-1. And if that's the dispositive fact,
is there anything to suggest that in the 3-on-1, even if one couldn't see bloodstains, my understanding is there were at least 20 stab wounds?
There were 20
cuts
in the fabric of the material, whether that, a single, but there were 11 stab wounds that he had suffered.
Fist fights are fist fights. At a certain point, somebody is stabbing somebody.
Your Honor, the point is this. The jury could have, and very reasonably did, I would say, conclude that Mr. Auer was aware that Mr. Churn was stabbing Mr. Dowdy. That, however, was not an inference that the evidence compelled. It was dark. He was wearing this dark-colored jersey. Mr. Auer was, if one believes the evidence that was admitted, at close quarters conducting a fist fight, not a one-sided fight. Mr. Dowdy, until he collapsed on the ground, was fighting back. He was arguing and saying things to these three men during the time that the fight went on. According to the evidence, as I understood it, Mr. Churn was standing on the other side of Mr. Dowdy, and there's Ms. Tran says at some point he was making underhand gestures with a closed fist, other times. But in any event, the knife itself, a very, very small one. And again, all of this becomes a question not of what the jury could have concluded, because I acknowledge that they could conclude that this was extreme atrocity, but that there were other options available. And most specifically, that Mr. Auer should be prosecuted and convicted of that which he did, which was to commit an assault and battery with a dangerous weapon.
But let me ask you this. If the joint venture resulted in a death, it may be that the lesser included offense to which your client was entitled, or that the least lesser included offense to which your client was entitled, is the manslaughter instruction based on a battery, because he is involved in a joint venture that resulted in death. Are you only entitled to the assault and battery instruction if you can show that there was some evidence that your client was not involved in a joint venture?
I would say the answer to that is no. That what this Court and others, and I want to make sure that I emphasize this point, because it's unusual to have a case that's so much on all fours, admittedly by the appeals court. It's persuasive authority. It's the Gilliard case, which I cite in my brief. In Gilliard, the defendant was prosecuted as a joint venturer. She was one of several participants in a spontaneous melee that resulted in a death. There was evidence by several witnesses in that case that they saw a knife. There was even evidence that she said, "Give me the knife." She later said to people, "Hey, I'll treat you the way I treated Ms. X. She's dead." And the appeals court held, number one, that she was entitled to an assault and battery instruction because there was also evidence that that was all she did. But in the face of the fact that the jury convicted her as a joint venturer of murder, though they could have convicted her also of simply manslaughter, that this court or that court can't be saying, well, look, this square peg is somewhat closer to the shape of this round hole than some other choice. That's what juries are entitled to do. They are entitled to have all the choices put before them and for them to make an appropriate decision based on what they conclude the evidence was. And yes, again, absolutely, this jury could reasonably have convicted, as it did. I mean, there's the checklist of and mark well the fact that there were 12 possible verdicts. I mean, this was very confusing. He was also being prosecuted as a principal on a number of those levels. Excuse me.
No, I'm sorry. Finish your thought.
Simply that except as to premeditation, he was being prosecuted both as a principal and as a joint venturer.
Did they have a special verdict slip?
They did, and it's reproduced in the appendix with the brief. It's
right. Okay.
Is there any evidence that your client was not involved in a joint venture?
Yes.
What is that?
The evidence would be that everything that suggested he was involved in a joint venture had to do with committing an assault and battery or taking part in a fist fight. It started as a fist fight. He was slugging Mr. Dowdy as Mr. Dowdy was slugging him. Mr. Dowdy at one point was leaning into his car because another fella had jumped into the car and was going to drive it away.
But what I'm hearing from you is that there was only evidence of a joint venture for assault and battery.
No. No, absolutely not. No, because it was up to the jury. Did he know that this other person somewhere during that struggle introduced a little, what they called pocket knife or pen knife with a 2-inch blade and was on the other side of him?
Yes. I just want to make sure I really understand what you're saying on this. Is there any evidence that he was not involved in a joint venture?
No.
Okay.
No. But the question is joint venture.
Yeah. For what?
What? And again, the time is quickly fleeting, and I wanted to make sure to bring to the Court's particular attention a couple of cases that I think answer some of the questions that Your Honors have posed to me. And they're cited in my brief, Commonwealth versus Dahl and Commonwealth versus Berry. And admittedly, there we're talking about what jurors did as opposed to what this Court did. But the point being that it is not insignificant that this was a spontaneous struggle. It's not insignificant that it was late at night. It's not insignificant that it was an argument that escalated into a fist fight. It's not insignificant that someone, in Dahl, it was somebody coming out of a house with a golf club, slugging the guy over the head with a golf club, breaking it, then stabbing him. And nonetheless, several of the co-defendants who, according to Judge Graney's recitation of the facts, were continuing to kick and pummel this guy, even as the other fella was stabbing him with a golf club, were convicted only of assault and battery. It's not an unreasonable suggestion that I'm making. It's going to be clear that as to the remainder of my issues, I'll need to rely on my brief. I do, however, want to call to the Court's particular attention the materials in the supplemental appendix concerning Mr. Auer's character, because I would suggest all three of the 33E issues are at play here. First of all, questions.
Were these affidavits introduced at the sentencing? I mean, there's no sentencing?
No.
There was no...
No. And it was just the usual, well, it's a mandatory, and let's move on. Excuse me, that first of all, there's the question about the weight of evidence. Second, his character. And as I point out, there really are some genuine issues here about introduction of evidence and the judge's rulings on various instructional issues, which present, if not error, reversible error per se, then certainly issues that the court should be aware of and concerned about.
Thank you.
Thank you for your attention.
Thank you, Mr. Stevenson. Ms. Smith?
Good morning again. Loretta Smith for the Commonwealth. The evidence of malice on the part of POV was overwhelming. The evidence of his participation in a joint venture to cause grievous bodily harm was overwhelming.
But there was some evidence that he was not engaged in malice, I take it. I mean, there is a view of this that entitled him to the lesser included offense of manslaughter.
Well, actually...
And that is that he didn't act on malice.
The judge, at the end of the day, decided that he wasn't entitled to manslaughter, even though he gave it. On the motion to reduce the verdict to manslaughter, the judge ruled that he was not entitled to a manslaughter.
Did the judge instruct on manslaughter?
Yes, he did.
Well, then he got the benefit of what he was probably not entitled to.
Yes, he did. And I submit there is no evidence that he did not act with malice. He was the one that provoked the entire incident.
But what's the evidence of intent to kill?
I didn't say intent to kill. I said intent to cause grievous bodily harm. From the beginning of the fight, first of all, the fight commences as co-defendant pushes up against Richardson, the neighbor, the friend. Richardson takes his hand and pushes Bullchurn back. Bullchurn stumbles. The fight begins. The verbal fight, however, preceded that, was provoked, as even the defendant concedes, by defendant Povauer. As soon as the fight begins, we've got 5 against 2, and very quickly 3 against 1. 2 of the gentlemen and Richardson leave that fight. So we've got three men fighting against 1.
Without the knife, if he did not know about the knife, is there evidence of a substantial likelihood that he knew that there was a substantial likelihood of the victim being killed?
Of death, yeah.
Of death. For third-prong malice, you have to show that he knew of the knife, don't you?
No.
In this case?
No. For extreme atrocity and cruelty, he does not need to know that his co-defendant possesses a knife. If there's malice in his own right, and I'm suggesting that the evidence establishes that overwhelmingly.
But the pathologist said that none of the bruises, none of the kicking and punching wounds would have resulted in death.
The pathologist testified quite clearly that there was one stab wound, which was the fatal wound. That caused the loss of blood and the collapsing of the lung. He did testify that the other injuries were, in the medical world, superficial, meaning that they did not cause severe damage.
Okay, so he doesn't have to know that there's a knife, but he still, as a result of the degree of the beating, doesn't it have to be apparent to him that death would result?
Well, as Tran testified, Povauer beat the man, punched him until he died. He was relentlessly punching and kicking the victim.
Was the jury instructed the way you just stated the law, that in the event of a verdict of first degree of murder in the first degree by reason of extreme atrocity or cruelty, the defendant need not know that the co-defendant was armed with the weapon if you determine that the defendant had malice, that there was malice on the part of the defendant? The jury was instructed to that effect?
The jury was instructed that way, and then then the jury was also instructed that to rely on the weapon for malice, the jury had to find that Povauer knew that co-defendant had the knife.
So they either didn't rely on the weapon if they didn't conclude or didn't find that Povauer knew the co-defendant had the weapon, or they found, following the alternative route.
Correct.
And we don't know which, correct?
No, we don't know which. And
That was partly, Ms. Smith, why I asked if there was any pullback at any time. I take it that Ms. Sland's testimony was such that she said she observed the co-defendant stabbing the victim.
correct?
Was she in a different, I mean, she was obviously in a different place from Povauer, but was she...
She was distant.
Where was she standing in
She was
relation?
standing next to the maroon Cadillac, which was Povauer's car, that was behind the double-parked car of the victim. She's standing next to the passenger side of that car. The fight is going on away from her. She sees the blade. Saren Chi, another witness who lived in a house next door to Richardson's, so he's across from where this fight is happening. He sees the glint of the blade, and he sees the arm going like this. So it appears to me inconceivable that Povauer, who is standing right next to his co-defendant, doesn't see it. And doesn't see it not only while he's stabbing the victim, while the victim is leaning into the car fighting with Mr. Chim, but also doesn't see it.
The jury were given both sides of that. They said, look, if you find he was in a joint venture and he knew about the knife, guilty. And if you find
He was in a joint
that
venture.
he was in a joint venture and did not know about the knife, as long as he's got malice, you can find him guilty.
Correct.
They had both sides.
Yes, they did, quite completely.
And all of that is correct law.
Yes, sir, it is. Okay, if you have no further questions, I'll
Thank you,
rest on
Ms.
my brief.